Judgment in the matter between the MK Party and the Judicial Service Commission was reserved yesterday following various arguments at the Gauteng South Court. The MK Party is seeking to have the JSC interviews where some 50 candidates will be interviewed for various vacancies in the judiciary halted. Now, this is because the Western Cape High Court ruled in favor of the JSC's decision barring John Hlophe from participating in any JSC activities. The MK Party is still appealing that ruling, and Judge Stuart Wilson will make a decision today, which will be circulated electronically. Now, let's take a look at the merits of the various arguments heard in court yesterday and the likely outcomes with legal analyst Melusi Xulu. Melusi, good morning. Welcome to Newzroom Afrika.
Good morning, Mr. Masechaba, and to the viewers at home.
Firstly, what are the key arguments presented by the MK Party in their court submission regarding the JSC matter?
I think my interest was when Advocate Dalimpof SC stated specifically that this is not about the quorum of the JSC, but it's really about the composition. If you look at specifically Section 178, subsection 1, paragraph 8, it says that the members of the JSC from the parliament, there must be 6 of them, and 3 of them must be coming from the opposition parties. So that's one of the arguments is raising, that it's not about the quorum, but necessarily looking at that the Constitution states this is the members that must be there. And the DA raising an interesting point that if these interviews are halted, the issue will be, there will be a lot of cost that will be lost there. And so they are saying that it can proceed without Dr. Hlophe. So when they raised those arguments, something came to me when I was reading the previous judgment on this particular matter at the Western Cape High Court. If you go to paragraph 69, Masechaba, there, the judgment says the interviews can continue without Dr. Hlophe, and if there is a need, the National Parliament or the National Assembly can designate someone that can be, nominated to come to these interviews for the time. So they say he can miss the meetings or the sittings, 1 or 2, until Part B of that particular hearing is done, where it will be decided whether the Parliament failed in its duty to designate a member of a Parliament to the JSC that is proper and fit, because the argument there is that Dr. Hlophe is not proper and fit because he was impeached in February as a charge.
Now, Melusi, the Gauteng High Court, as we know, will today hand down its ruling on the MK Party's urgent bid to postpone next week's JSC interviews. What are the potential consequences if the court dismisses the MK Party's application?
I'm of the view that the interviews will continue. I mean, it's an urgent application to halt the interviews from the 7th of October. As you stated, 50 or more candidates will be interviewed for judiciary positions. So the interviews will then proceed, and a sitting or 2 will proceed without Dr. Hlophe being there. And then eventually the hearing on Part B of that particular hearing will be then decided. And one of the important sections which are important here, Masechaba, there's a section in the Constitution, it's section 167, subsection 4, paragraph E, that says the court may decide if the Parliament or the President failed in its obligation to fulfill the Constitution. So basically, that will be the critical decision that the court will be making in this matter, whether the Parliament, specifically the National Assembly, failed in its obligation to fulfill its constitutional obligation. Because the issue here, if I may get a second, is the courts previously in the Western Cape, it said the National Assembly failed to see that they actually have a discretion on who they can designate to the JSC. Meaning, although it's not specific how you can disqualify to be at the JSC, but the National Assembly has an obligation and a discretion. So that will be the critical part where it will be decided whether the National Assembly have failed to say that Dr. Hlophe does not qualify. But my interest, before you let me go, is there a specific section in the Constitution that says you cannot be a member of the JSE? There's not a specific section, but I suppose there are sections that I've just mentioned that can be read into the Constitution to say that he cannot be a member of the JSE.
And most critically, what role might the ruling play in shaping the future of judicial appointments and the independence, especially, of the judiciary in South Africa?
Well, the role of this judgment, should it say that Dr. Hlophe cannot be a member of the JSE, is to simply try to expand on Section 165, subsection 4, I believe, that says the organs of the states, through legislative and other measures, must assist and protect the courts into making sure that there's independence, there's impartiality, and there's effectiveness and accessibility, in particular to justice. So it means when you go to be a member of the JSE, it must be properly also scrutinized whether you do qualify, looking at your history. Although it's not specifically mentioned, because, I mean, Masechaba, if you look at how you become a member of a JSE, first of all, you must be a member of a parliament in terms of Section 47. You must qualify, you must not have been imprisoned and so forth, as you've seen in the case of the former president, Xulu's. Then after that, you are voted by the people in the parliament, and then you become one of the 6. But now it's specifically saying, as much as you are voted into be a member of the JSE, the National Assembly cannot just rubber stamp that. They have to decide whether you still qualify in terms of the Constitution. That's why I mentioned Section 167, subsection 4, paragraph 8, that says the courts may decide if the Parliament and the President fulfill their constitutional obligation, which means every decision will be looked at based on the constitutional measures.
The DA's legal representative, Michael Bishop, said state organs can't stop functioning because of people seeking to review court decisions. Now, is the MK Party's legal challenge causing disruption to the functioning of the JSC?
Well, that's a very interesting point. But I think what is important is this. Is the disqualification of Dr. Hlophe constitutional or not? So that when the organs of the state, such as the JSA, are working, everything must be looked at based on the measurement of the Constitution. So I am saying, as much as the organs of the Constitution or the organs of the state specifically must be functional and working, everything must be looked at based on the measurement of the Constitution, whether his disqualification was constitutional. And if there's a dispute about it, it has to be looked at so that at least there is fairness. The interesting thing that the DA raised, which was something that before court, was also the fact that is it in the public interest to halt the interviews just because Dr. Hlophe is not happy about it. I think that's one of the arguments that the DA is raising, that based on the public interest, they must continue. But all I'm saying is, at the end of the day, everything must be looked at through the eyes of the Constitution so that there is fairness. So if there's an unconstitutional aspect of Dr. Hlophe's disqualification, maybe at a certain point, the organs of the state may have to be halted so that is looked at. But right. my view is, when I looked at the previous judgment, is that, I think today's judgment, and maybe I'm being too bold, but I'm just reading into the fact that maybe the judgment will look at the fact that Dr. Hlophe may miss a sitting or two until right. Part B is dealt with. So maybe the matter may say, the interviews must continue. Okay,
so Melusi, what impact will the forthcoming appointments of over 50 candidates and judges to various court vacancies have on the judiciary and the administration of justice?
Well, the impact will be basically the important thing is when the judges are chosen, are the judges chosen so that the courts can achieve independence and impartiality and also effectiveness. That is what is important. And if they are chosen based on that, it's a constitutional obligation based on 165, as I said. So if those judges are chosen based on that, I think it will be good for our justice system. So as much as the judge or Dr. Hlophe may not be there, I think what is important is that the judges are chosen and they are chosen to ensure justice in our courts. But what is interesting for me is his disqualification, inverted commas, based on the Constitution. And I think what is interesting here is, Masechaba, I don't think the people who drafted the Constitution saw this coming, where a member of the JSC would be a person who was impeached. So it's an interesting angle that has never been thought of. It's a new thing. So it's going to develop our law in a good way. But ultimately, at the end of the day, whether Dr. Hlophe is there as a member of a JSC or whether he's not, and maybe he's replaced by someone else, the important thing is the judges that are chosen and that are successful, they must be judges who ensure that there's justice in our country.
All right.
Obviously, our country is based on the Constitution, so that the Constitution can be protected for our people.
Thank you very much for your time, Melusi. That was legal analyst Melusi Xulu ahead of the ruling, which will be shared electronically today.